There's so much been said about the events of both last Friday and yesterday, where a budget was passed by voice with no opposition, no debate, no budget books and no budget lockup, as is traditional over the years. These came following Friday's surprise turn of events when a good number of government ministers and members moved to opposition, and the opposition, using its numerical strength, moved the motion to adjourn Parliament to December 1st, presided by the Deputy Speaker, Connie Iguan, with the Speaker resuming duties on Monday, identified a loophole in the adjournment process and called for Parliament to resume on Tuesday 10 a.m. And when Parliament met on Tuesday 10 a.m., only one part of the House was full, and because they had a quorum, they proceeded with the passing of the 2021 appropriation bills and the budget. All these has drawn criticism, both positive and negative, from citizens far and wide. Alois Jerewai is a private practitioner and, as a senior lawyer, provides his interpretation of the Organic Law, Section 21A1, on which the Speaker relied on to call for a resumption of Parliament yesterday.
The first is that, in his absence, the acting Speaker who acted in his place had already entertained the motion and allowed it, and the resolution was carried, and the Parliament was adjourned. And on the principle of functus officio, the Speaker cannot return after that absence and revisit the acting Speaker's entertainment of the motion.
He says the Organic Law suffers a major constitutional issue as it restricts the rights of other MPs to move motions, a right given to them under Section 50 of the Organic Law.
Namely, the right to move a motion to fix a meeting of the Parliament. And for this law to be valid, it must say that it will restrict that right. And that right arises under Section 50 of the Constitution, subsection 1, C, D, and E, and also subsection 2, which gives every one of us the right, through our leaders, to engage in all matters of the Parliament.
And Jerewai cites similar cases in the past.
For instance, I was involved in the application to the Supreme Court to nullify the NCDC, National Capital District Commission, Amendment Act that removed members of Parliament from the board of the Commission of NCDC in 2001.
His advice is for the Speaker to take the initiative to correct this before December 1st.
However, the most expeditious way in which the Speaker can have these issues resolved is to seek the advice and interpretation of the Chief Justice, and if necessary, the Chief Justice and other senior judges in court.
Meantime, the Speaker on Monday defended his clerk's failure to advise the Deputy Speaker of his oversight. He said they all were caught in the events of Friday, where there was an exodus of members to opposition. To this, Jerewai said, a clerk of Parliament should always be a lawyer, someone who knows the law. This would have helped Parliament avoid such a blunder. Their failure to advise the Deputy Speaker well has led to a chain of events. The opposition is understood to be in the process to file a case against what happened yesterday. Ruth Rungula, National EMTV News.